the only plenary session we will have today, and it is also the last plenary session of this conference. For this very important last plenary session, we have an amazing lineup of speakers. And the first one, our keynote speaker, is Martijn Snoep. He is the chairman of the ACM, the Dutch Authority for Consumers and Markets, and he will speak about the green and digital transition from the perspective of an enforcer. Martijn, yeah, you have the floor.
Thank you very much. It's a pleasure to be here. The last time I was here, I think in this very room was with my daughter at the introduction day of the university. Eventually, she decided to study physics, so I tried. It's a pleasure to be here again and to speak to you about sustainability and the role of a market authority like the ACM. And I thought I can in no way meet your academic expectations. So this is going to be a more policy perspective from a competition / consumer / digital / energy / transportation / telecommunications authority that we are, because that's what we are. We are a multifunctional authority that enforces market regulate different market regulations in the Netherlands. We are around 650 people, growing to 800 if the government fulfills its budgetary promises. And we do that on, we enforce various laws in the Netherlands. And the main threat and an important common thread of these laws is that these are all European laws, European laws. And that makes it institutionally that we are in an interesting position. And I tend to say also, and also express this as part of our philosophy in the agency, is that we are a European enforcer in the Netherlands. And that's how we relate ourselves also to the European Commission, to the other European institutions, to the European courts. And that also means that how we operate, you will see, if you look at our website, that is a significant part of our decisions, of our guidelines, things that we do are in English, just to show and to also part of an international community that enforce European laws throughout the territory. We have, as an agency, we have three major objectives. And you have to realize there is some of the work that we do, we have no discretionary power. So if the merger is going to be notified at the agency, we simply have to assess the merger. There is no discretionary power to decide yes or no to decide it. But when it comes to the selection of cases, we have full discretionary power. So the question, of course, for an agency like ours is, how are you going to fill in that discretionary power? And in order to do so, we set three general policy principles, three themes on which we are focusing. The first is to expedite the energy transition that is necessary. So we're also the energy regulator. So logically, a lot of the work and power that we have and that we devote to energy regulation and the enforcement of energy regulation, we spend on expediting the necessary energy transition. And that means that we do a lot of work in the grid expansion, which is necessary to allow the change from fossil fuels to electrons, to electricity, which requires a massive investment in the grid infrastructure and throughout Europe. The second objective is that we support the transition to a more sustainable economy. And you notice the difference in wording. And we expedite the energy transition, but we support the transition to a more sustainable economy. The reason why we use different wording here is that we believe that for the energy transition, there needs to be a much more expedited process in order to allow not only from a sustainability point of view, but also from a security of supply point of view, that we need to change our energy markets. Of course, there's also, and that's why we decided to play an active role there. It's also the transition to a more sustainable economy, is of course also necessary, but it is a more long-term project where a different role of a independent government agency like the ECM is required. And finally, the final objective is create and protect open and fair digital markets. So this is the three: energy transition, sustainable economy, and digital, open and fair digital markets. Those are the three objectives, how we use our discretionary power to select the basis. And what do we do in practice? We, if you look at the support for the transition to a more sustainable economy, and now coming also closer to the domain and to the topic of the main topics, one of the topics of the conference, is that we provide general and individual guidance to sustainability agreements between competitors that on the one hand reduce competition, but on the other hand also provide and support and help the transition to a more sustainable economy. We, as some of you may know, we drafted guidelines. We have two versions of guidelines, which is how we look at sustainability agreements. And we have a number of cases where we gave individual guidance to companies on their agreements. To give you one example, which I think is a very interesting and also innovative example of how we apply the law, is a case where garden centers, so retailers that sell plants to consumers, agreed to blacklist suppliers that use illegal pesticides. So the use of illegal pesticides among plant growers was pretty endemic, and hard to detect, and little enforcement capacity by the health and safety authority was devoted to the enforcement of the pesticide laws. And therefore, the garden centers, under pressure from non-governmental organizations, entered into an agreement where they said, let's abolish the supply of plants that are being used by for which illegal pesticides are used. We set up a private monitoring and detection system. Plant growers that have been found to use illegal pesticides get a warning. And with a second warning, they're being blacklisted from the supply to all the garden centers at the supply agreement. Normally, you would say collective boycott, because this is a collective boycott, would be illegal under the competition laws. But in this particular case, we made an analysis and said the competition laws are not designed to protect illegal or illicit competition. So competition that is not on the merits, competition that is based on illegal practices. And therefore, the entire agreement falls outside the scope of Article 101 and the equivalent under Dutch law. And I think this is an important precedent. This was also something that we discussed with the Commission. And these types of what we call now compliance agreements, so agreements on companies either to comply with the law themselves or ensure that their suppliers comply with the law, are maybe an interesting precedent for other, and provide inspiration for other companies to we will follow suit with similar initiatives. Today, we, for the first time, actually, we publicly prohibited or gave negative clearance to a sustainability agreement. To be honest, from a policy perspective, I'm extremely happy. And the reason is that we wanted to, show and be able to communicate that, we are not blind. We are not, we do not fall for every greenwashing story that companies feed us. We remain critical. But what happens in practice most of the time is that companies that come to us and then we say no, they say, and then we say, okay, we can give you guidance, and they said, nah, don't bother. And then we have nothing to be able to make public. This time, the company said, yeah, we would like to receive the guidance on paper, so we did. And then he said, yeah, we like to make it public. And they said, no, it's all confidential. And we agreed, so we can't make this public. But I also told them, if you make it public, we're going to do it. We're going to do it too. And fortunately, the chairman of this organization had a slip of the tongue in an interview and made it immediately public. And I thought, now I got you. So today we issued a press release on the negative clearance of this agreement, negative clearance, negative guidance on this transaction. And what there is a European-wide initiative to reduce single-use plastics, and it's a bit I won't say this too out loud. You can think differently about the legislative quality of the directive. But the aim is good and laudable, but the instrument is a bit strange, because actually what the instrument, the directive, suggests is that companies add a surcharge for the use of plastics. They can keep the proceeds in their own pocket, and they are under a very weak obligation to use the proceeds to invest in more sustainability. It's not concrete. There is no enforcement. There is no transparency obligations. There is no justification of that. So basically, the idea is, you increase the price of single-use plastics in the hope that customers will no longer use single-use plastics, but at the same time, it also increases the profitability of the companies. So at this time, the companies came to us and asked whether they could agree on a fixed surcharge for for single-use plastics. And we said, no, you can't agree. They said, well, this will lead to a race to the bottom, because then we're starting to compete on the surcharge. And that will be in contradiction of the aim of the directive to reduce single-use plastics. Because of the reasons that, first, we were not convinced that it would indeed lead to a race to the bottom. And second, we were not convinced that the surcharge would lead to a reduction of single-use plastics. We said guidance, we cannot give positive guidance to this agreement. So therefore, these are two cases of general and individual guidance. Now, the wider context, European context. In the meantime, you've probably seen that the European Commission issued the final version of the guidelines, the horizontal guidelines, with the sustainability paragraph in the guidelines. And those guidelines differ in two important aspects from the ACM's guidelines. The first is that on compliance agreements, so the types of agreements of the plant retailers, that the European Commission is much more strict on the type of compliance agreements that are allowed. They say the compliance agreements that are needed to implement sufficiently precise international obligations are considered to fall outside the scope of Article 101. So agreements that are aimed at complying with domestic legislation or European legislation or kind of broad open legislative objectives are not allowed, fall inside the scope of 101. So therefore, we have to find a way of closing that gap. And then secondly, big debate, something I'm sure that's been discussed with those of you who are interested in the sustainability debate in competition law, is about the question whether the consumers in the relevant market need to be fully compensated by the benefits, or whether, as the text reads, a fair share of the benefits is sufficient. This is a hotly debated topic where we have a difference of opinion with the European Commission on the interpretation of the law. But on the other hand, it's also a little bit of a theoretical discussion, because when we look in practice and you look at the types of agreements that we want to clear and that we want to prohibit, the European Commission and we are most of the time aligned on the objective. So therefore, there is more. You know, it's a fun topic. I've talked about the topic a zillion times, and I love the topic. I'd love to talk about the topic here a bit further if you're interested. But in terms of practical relevance, so far it's not that relevant. On the sustainability front, we're also active, obviously, outside the competition area. We don't go into detail, but just to mention is that greenwashing is a form of misleading advertising, and so in our consumer protection role, we are very active against various types of greenwashing. We've enforced the laws against two well-known clothing companies, Decathlon and H&M. To domestic suppliers, and we intend to continue and to enforce the law. So we have a couple of pending investigations at the moment, and I cannot reveal the identities of companies, but this is high on our priority agenda. The reason is somewhat related also to competition, and because we believe that if we do not fight against greenwashing and misleading sustainability claims in advertising, then what will happen is that companies will no longer have an incentive to differentiate themselves from other companies in the area of sustainability. So if you invest in sustainability, in a more sustainable production process, and you are advertising this, and your competitor can do exactly the same without the cost of investing in anything, then of course, it's a free rider on your investment, and you will stop to continue to invest in more sustainable production processes. So that's why we see that consumer protection here is a complement to competition policy. We also are preparing for a role in the Diligence directive once that's implemented in the Netherlands, and the Supply Chain Act. So there is a discussion in the Netherlands for a similar Supply Chain Act as is available in Germany, is applicable in Germany and in some other countries. So on the role of supply chain management and due diligence obligations within the supply chain, we are preparing for a role. So this with respect to sustainability. Now coming back to the digital markets, kind of the second leg of our activities in the Netherlands. We focus from a consumer point of view very much on dark patterns and other digital techniques to influence consumers negatively. We issued a guidelines on online consumer protection and ways to detect new dark patterns that we go back to the consumer biases, human biases, and have a particular emphasis on the protection of children in an online environment. I think, for example, about games where children are being targeted and influence to spend as much as their parents' money as possible. If you have children, you know what I mean. And so we're preparing for a number of enforcement actions in this area also to make sure that in this new digital environment, the vulnerable in our society are better protected than they are at the moment. Then two areas which are very much competition related, where we are focusing on, that is open and fair, transparent, open and fair platforms. So the platform economy is something that we're looking into, and vendor lock-in. That's also an important theme in which we target our enforcement actions. So on the latter, the vendor lock-in, maybe you've seen that we issued a study into cloud services and cloud service operators, where typically there is the issue of vendor lock-in. It is something which we found difficult at the time to target with our regular competition tools, and that's why we advocated for stronger and improved interoperability data with the rules of the Data Act. And we are now also advocating internally in the Netherlands for a new competition tool. For those of you who made prior to the Digital Markets Act, the European Commission asked the European Parliament, or consulted the European Parliament, on a broader tool that could be used across markets and not only against platforms. That was coined as the the new competition tool, similar to the market studies instrument, the CMA, Consumer Markets Authority in the UK has, and that is now being discussed in Germany under the amendment of the cartel law. And the European Commission wanted to have that too, but they didn't get it. And now we want it. And so we are actively debating in Parliament and with the Ministry of Economic Affairs to get this tool, because we think that that could be used as a tool in markets where, as a result of vendor lock-in, there is a reduced level of competition. Now coming back to the final point, that is open and fair platforms. There we have a number of initiatives. First, as we look at self-preferencing of retail platforms, that is not yet in the public domain, but we have a couple of cases there running. Same goes for monopolization or leveraging in after or secondary markets. So the platform, a dominant platform, uses its power to monopolize or leverage into an adjacent market and try to monopolize that market as well. We are going to announce, sorry, I wish I could have announced it today, but we're going to announce next week, end of next week, into investigation into this area. And then we are preparing for the role as the Digital Service Act coordinator. For those of you who are following the implementation of the Digital Service Act, each country needs to appoint a Digital Service Act coordinator that coordinates the activities within its own territory. So we're going to be that coordinator for the Netherlands, and of course, enforce the DSA in the Netherlands as well. For the DMA, that's also been discussed during the conference, there is a limited role for the member states and the national authorities, because the idea, particularly from European Parliament, was to centralize.
5 minutes.
To centralize enforcement in Brussels. And there we came up with an initiative to help the European Commission by setting up joint investigative teams, where we will jointly with the European Commission run investigations into compliance with the DMA. And that is a new model of institutional cooperation that those of you who are interested in institutional workings in competition law and how the relationship between the NCAs and the National Competition Authorities and the European Commission plays out. This is the one to follow, because my prediction is that this is going to be the trial ground for room for experimentation for a model that we're also going to use in the next generation Regulation 1/2003. So joint investigative teams in the enforcement of general European competition law outside the area of the DMA. Now, the final word in 3 minutes on our investigation into the Apple App Store. You might have seen that. We, after a general market study on the App Store market, we initiated a case against Apple based on unfair trading conditions. So we used 102A rather than a leveraging theory or exclusionary abuse. And it was, I can tell you that how to discuss it because I find it kind of amusing. We started out with a exclusionary abuse case, and then the Spotify complaint was filed in Brussels, and then the Commission came back to us that how we're going to divide the kind of the cake. And by the way, we want the exclusionary abuse. You could have exploitative abuse, and I thought at the time that's a pretty good deal because I think you are going to have more problems with the exclusionary abuse than we with the exploitative abuse. They've proven me right because, as you see now in the revised statement of objections in the Spotify complaint, they've changed from an exclusionary abuse to an exploitative abuse. It's a funny story. It's not, there's no rivalry or that, but sometimes you see that, if you have a fresh look at old laws, it's kind of interesting. You find new things. So now we are coming back and we are at the stage we issued the decision. We survived an injunction. Most of it, 75% of our case was survived the first injunction in court. We now need to do an extra internal review, and we hope to issue a new decision as soon as possible. But what is interesting about the case is that we go back to case law of the 70s and early 80s of the last century, where this was slightly developed. For example, in the context, which I thought was great, is the famous case, and I studied famous cases, I think since then not so famous anymore. It was the Nederland case. So these were trucks, and trucks, of course, in Europe have the steering wheel on the left hand of the truck, and in the UK it's on the other side. And so what did Leyland and they allegedly had a dominant position. I don't know whether they really had, but okay, let's forget about that part of the judgment. And the trucks with the steering wheel on the right side were sold at a significantly higher price than those on the left side. And therefore the Commission made a case that this is an unfair discrimination of prices. It was totally unjustified. There was no economic value, nothing was based on, and they said, that differential constitutes as such an abuse of a dominant position. We apply that same theory in our App Store case, where we say, so for those of you who know the App Store, how it works is that if you buy in an app online services, for example, dating services through the online app, then Apple charges 30% of the revenues. But for example, if you provide the services outside the app, like Uber or Amazon, where the goods are not provided through the apps, there is only $99 per year. So it's a huge discrepancy between 30% of your revenues and $99 per year. And we said that this is an unjustified justification. The only reason why you do this is because you can. And that cannot be, if you're dominant, that is not enough to justify an extreme form of discrimination. We're not arguing that all right, but at least less unequal as in this case. So this is a general overview of what we're doing in the area of digital economy. I hope I give you some ideas what it is. If you look at the topics that you're studying, and that you're researching from a policy perspective, forces perspective. And I'm more than happy to answer any questions that
Many thanks for this very informative and rich presentation. I'm sure there will be many questions. Who wants to go first? Konrad.
Yeah, thanks for your presentation. I was wondering about, I'm doing quite a bit of research on collecting quantitative data about app stores, trying to get insights into the app use of dominance. How do you usually engage with academic researchers as an institution?
It's hard to give that in general, but a comment on that. But for us, academic institutions are extremely important because there is a huge information asymmetry between us, the national competition authorities, and the European Commission, and the big tech companies. And the only way to mitigate that information asymmetry is to use as many resources on the side of the competition authority as possible. And so we very much engage with the academic community, with non-governmental organizations, with individual specialists, and also in this App Store case, that's exactly what we did. Because the development of the case was that at one point in time, Apple had to comply with our order. And of course, then you come into the discussions, in a very specific order, how they had to comply. But of course, we could not detail every nitty-gritty point. How could we know that we weren't fooled by Apple? And that's why we engaged not only with the complainant, but also with many specialists, academic specialists that gave us feedback on the proposals made by Apple. And that's why we ultimately, well, took a while, 50 million euros later, Apple complied with the order.
Yes.
Hi, Irina Mustava, CPC here, Maastricht University. Thank you very much for the talk. And I was very much fascinated by your comments about the need to enter some additional arrangements in order to be able to effectively enforce the competition rules, but also other rules in the European Union context. And I was just wondering, coming from the data protection perspective, whether you see the need to, in fact, put in place those rules in order to, in fact, collaborate even with EDPB or national data protection authorities. Paul Nimitz, the European Commission, at some point stated that, in fact, this is something that the European Commission is looking into already. And I was just wondering whether you've already maybe established certain type of collaboration in this area. Thank you.
Yes, we did. But to be fair, all credit goes to the UK, where they at some point in time set up the digital regulators cooperation platform. I think that is something like that. And the moment this is how things go. At the moment I saw that announced, I immediately thought, we need that too. So I called up my colleagues at the Financial Conduct Authority, the Privacy Authority, and the Media Regulator, and said, let's sit together and copy this model. And they thought it was a good idea. So now we have a similar cooperation forum, which is between the four agencies. We, as chairs of the agencies, we sit together on a very regular basis to decide kind of general policy issues. For example, how are we going to interpret and assess transparency? Transparency is sometimes seen as a cure for everything, but what about effective transparency? And when do we believe transparency is?
Beyond that, also exchange information on specific cases as well. That's
So
very interesting and unusual.
So we talk so at the gym, and then at one level that we exchange cases on concrete cases, and then we set up two separate specialist chambers, one for the Digital Service Act to coordinate and cooperate our work also with other agencies, because other than the 4, there will be other agencies involved as well, and one for the AI, so where we have a similar cooperation model. And so far, it works really well. Okay.
Good. Last question. Yeah. Okay.
Hi, I'm Konrad. Actually, I'm PhD in Maastricht University, and I have a question about guidelines that published by ACM. Last year when I did my research, I found that actually in Europe, member states try to take the different measures to regulate digital markets. For example, the Netherlands published the guideline, as you mentioned, but Germany tried to revise its Competition Act. So I wonder that why, for example, the Dutch government want to choose these soft law measures to protect consumer welfare, and why you didn't try to propose like the revised Competition Act or Consumer Protection Acts, this kind of measure. And another question is that what do you think about these guidelines, how it's play its roles in markets, like is that really provide guidance to undertakings? Is that really useful for the for undertakings if it has no legally binding force to courts? So thank you.
Oh, very good. So this also has something to do with whether you do something with guidelines or in the law. It's also a little bit to do with the philosophy, and in the sense that we see that there is a lot of room in the laws that we are asked to enforce. So before we go to the government, we cannot set our own rules, but we can set guidelines. Before we go to the government and ask Parliament to change the law, we do our utmost to solve the problem within the context of the current law. Because once you put a law on the wagon, you also don't know what you end up with. There are many examples of changes of laws that through amendments in the political process have turned completely into the opposite direction of the. So I'm also usually quite careful for changes in the law. So this is, and second question is, how useful are guidelines? So the way we use guidelines not only to give guidance, but also as a way to ensure compliance. Because what we do, we set up, first we do a general notice we are going to make for draft guidelines, come up with your ideas. Then second, we have a draft guidelines. We have open consultation process, public hearings, and all the businesses, everyone, the NGOs, everyone can participate in the drafting of the guidelines. And then we issue a second draft, sometimes a second draft, or sometimes the final version. Sometimes we have subsequent guidelines. So, for example, in the guidelines on consumer claims, we're already after 2 years, we're coming up with revised guidelines. And the feedback that we get from businesses is that they find it very helpful because it's better explained, it's simple human language, not legislative language, but just in normal sentences, what we expect businesses to do and not to do. And they are binding on us. So we cannot enforce the law in a way that is contrary to our guidelines. So the only risk is that there is private litigation where the courts say, yeah, the hell with the guidelines of the ACM, we'll decide on our own what the law says. And that has never happened. So also for the courts, our guidelines tend to be a very relevant instrument of their own interpretation of the law, as long as it's a sensible within the boundaries set by law and case law by the courts.
Try to keep your question short, please.
Okay, I've got two very short questions, one closed question and one open question. First question is, what will happen to the ACM's draft guidelines following the new horizontal guidelines? Will it be revoked? Will it be amended, or will nothing happen simply? Secondly, yesterday I attended a very interesting session by Tamta Marquez-Veli from Free University of Berlin on how to integrate sustainability into online sustainability and smart online selling restraints within selective distribution systems. And I was wondering what your thoughts are on integrating sustainability in selective distribution systems in general.
Start with a lot. I have no thoughts about that. To be honest, never thought about it. And also, as an agency, we are hardly ever involved in selective distribution systems. And so these are, when we do take enforcement actions, we really focus on kind of hardcore horizontal or vertical restrictions, and leave more like selective distribution issues to private enforcement. But well, good changes. I'm also always willing to take up a good case, but this is not where our enforcement priority lies. So I've never thought about the blank answer. About the first question, what we are going to do with our guidelines is we're going to amend them and follow the European model. But we have discretionary power, and the Commission cannot influence our discretionary power. So you have, these are the Commission guidelines and say what is okay. These are our guidelines, everything what is okay, and there's a gap, and we're going to use that gap and say in that gap we're not going to enforce the law. And we'll publish this after the summer. We're now in discussions also with the European Commission on the text of that guidance paper, but that is how we are going to propose to solve this issue.
Okay, thank you.
Thank you.
1 minute for the question and 1 minute for the answer. Julian?
I think that was the question, but like I did have another one. So given that after the summer you'll have
after summer, you'll have most likely quite some time at hand that you as an agency spend previously on sustainability. So can we then see new initiatives to push EU competition law forward in new directions? So just like.
No, I think what we are going to, we'll continue to spend quite some time on sustainability agreements, also in the agricultural sector, where there is an agriculture-specific exemption that is now being discussed. Fortunately, a big agricultural agreement failed in the Netherlands the day before yesterday that could have solved a lot of issues, but I hope that something will survive after the summer. So I expect that the people, so we have about 5 people who are working on this permanently. In the other areas, where can you expect developments, new developments? I think this is what we'll have, and I wish I could have announced it here, but I think we have exciting news in the area soon of abuse of dominance and sustainability, where we will initiate a big case against a worldwide player that uses its dominant position because of its non-sustainable distribution policies. I think I have to like that. A bit vague, but this will come out soon. So this is going to be an important task. And I think the other area in competition where there will be developments, the further development of the exploitative abuse theory in the Apple case. So there's plenty to come for the aficionados of competition law.
Good, wonderful, thank you. Good. Our next question online. Yes, we are running out of time. Very quickly then on Oles.
Yeah, thank you very much for fascinating keynote. If I may ask you, I noticed on the ACM quite a lot of guidance on platform to business regulation. It looks like it's kind of forgotten with the DMA that we have already a toolkit which leaves greater discretion to national regimes to introduce enforcement and sanctions mechanism. Does the authority plan to be more proactive in this regard? Thank you.
No, thank you, Wallace. You're absolutely right. The platform to business regulation, I forgot to mention, but that is indeed on our priority list. We issue guidelines, and we are now in the process to think what is in the public domain yet, but I think it's relatively public that we are now doing a sweep across different platforms to see how they comply with the platform to business regulation. And then we'll take another couple of other steps to ensure compliance, because I think this is important key. It's also how we look at ourselves. The goal of the agency is not to impose fines, but to ensure compliance. And sometimes compliance can be achieved, and can best be achieved by imposing high fines, but sometimes other policies are necessary for this objective, particularly when it comes to new laws.
Okay, thank you. The next speaker then, Konrad Kollnig from Maastricht University.
See if it works. I don't know. Yeah, thanks very much for the invitation to speak here. I'm going to present some work that I did with the wonderful Faure and the wonderful Caroline, who just a few days after I had signed my contract with this university in January, reached out to me and said, well, you're not officially here starting yet, but how about we do something along the lines of competition law, consumer protection law, and something technical. I filled in the technical bits in this piece on Ticketmaster. Kalpana worked on the competition aspect, and Caroline on the consumer protection aspect. It's going to be a bit of a ride. There's going to be elements of US law, EU law, Belgian law, Taylor Swift, Springsteen, Google DeepMind, and AlphaGo, a wide range of things, and I hope it's going to be interesting. How many of you are familiar with Taylor Swift? Maybe how the start of her latest tour was a bit of a failure because Ticketmaster, which is the sort of primary, the largest ticket website online, crashed under the demand for Taylor Swift tickets. They claimed, well, we experienced extraordinary high demand. You can see the internet traffic at the bottom, where sort of on the 15th of November last year we peaked. They also claimed that bots were partly responsible for this high traffic. Talk about that later, whether that was actually the case. Bruce Springsteen too experienced problems with Ticketmaster. Ticketmaster a few months ago employed a strategy called dynamic pricing for his latest tour. It blew up in the Bruce Springsteen fan community. The Backstreet magazine, one of the biggest magazines of Bruce Springsteen, was discontinued. Very controversial. Bruce Springsteen wasn't quite aware of Ticketmaster implemented the strategy, and $2,000 in prices for 2 tickets might seem a bit extraordinary. So this really raises the question of, can it be that the largest online ticket platform cannot meet demand? Might they be abusing their dominance in setting prices? And also, what role do bots play and how to protect against bots in buying online tickets and snapping up tickets? And
Go ahead.
Put that on the mic to see if you hear a sound. See, it's not on.
oh, right. This is right now.
Shall I help?
Okay.
That isn't.
Fantastic. You know, what roles do online bots play? Because not just the primary markets, but also the secondary markets for online tickets nowadays play a huge role. And often tickets on the secondary markets, these sort of reselling platforms, get sold for much higher prices than initially. So there might be an incentive for people to use bots to snap out lots of tickets and then sell them at higher prices. Let's first talk about the US competition law perspective. Ticketmaster actually emerged from a 2019 merger between Live Nation and Ticketmaster, who at the time were some of the largest providers in the field, and they formed an entity called Live Nation Entertainment, which is now the world's largest vertically integrated live entertainment company. It now has over 80% of the global market share in sort of these ticket platforms worldwide. The proposed merger in 2019 caused scrutiny by competition authorities around the world. First and foremost, the DOJ, the US Department of Justice, under the Clayton Act, and they decided to adopt a subject of structural and non-structural remedies in response to that merger, but to allow it pass through. Ticketmaster and Live Nation had to divest some of their technologies, and also commit to not discriminating against certain competitors. And at the time, this was seen as particularly innovative because of the use of non-structural remedies in the case. But going back to it, sort of realizing that Ticketmaster doesn't seem to be able to manage demand, maybe maybe that was a mistake to sort of let the merger go through as it did. And so actually, ever since the merger happened, there have been complaints against LNE. Many of the complaints relate to something that's called strip pricing, where you see one price when you sort of want to buy tickets, and then say lots of additional fees get added, and the price explodes. Also, Bruce Springsteen, not just last year, but also when the merger came about, he was furious at how what business practices they were employing, because apparently there used to exist two different platforms, and in the context of the merger, a lower price platform, instead of letting people booking their tickets, then redirected people to a higher price platform, causing annoyance in the fan community, and also potentially leading to higher prices. So actually now, last year, the state attorney generals launched legal action that requested a divestiture of NLE, and as part of that, they received 2,500 complaints against Ticketmaster within days. So these things really raise the questions: is our current approach to non-horizontal mergers adequate? Or might we, in response to these concerns, again see a new complex mix of structural and behavioral remedies in the Ticketmaster case? Now, changing gears, changing to consumer protection law. So, as I mentioned, bots might play a role in sort of driving prices for tickets, making Ticketmaster crash over demand. And actually, EU law in the 2019 EU Modernization Directive added some interesting clarifications on bots, on the resale of tickets, which says that the sort of purchase of tickets by electronic means, and that could be bots, has certain limitations. As Caroline pointed out, there are also some gaps in the EU directive, notably that the directive only applies if the retailer is a trader and the purchaser is the consumer. So, if just consumers selling to consumers, then these limitations do not apply. EU countries under the directions are allowed to go beyond the restrictions of the directive, and actually Belgium, ever since 2013, has an act that contains broader regulation on the resale of tickets. And this regulation, this act prohibits any sale by a natural or legal person who is not the original seller, and also prohibits regular, occasional resale at a higher price than the price set by the original seller. So, me personally using a bot to snap up Taylor Swift tickets and then selling that at higher prices would not be something I'm allowed to do in Belgium. They've been sort of monitoring this act, how it's been implemented, and interestingly, they've seen a decline in sort of infringements that the sort of responsible authority identified, but at the same time, the number of complaints rose from 619 in 2007 to 800 in 2019. So it seems like that the problem around sort of unfair practices around trading online tickets remain. Are you bot? I'm sure many of you are familiar with this question. Yeah, can be quite annoying to see these pop-ups, but shouldn't these things be applied by Ticketmaster to protect against bots, and why don't they, and why maybe might they not work? So I'm going to give a very brief history of these sort of are you bot questions pop-ups. And back in the days, 10, 15 years ago, we actually used to use a different version of these captchas, which sort of ask us to identify sort of what text was written in an image. You would type that in, and sort of by measuring something that's called task performance, the system would try to determine whether you're a bot or not a bot. However, with sort of very sophisticated computer systems, the rise of computer vision, machine learning, this is really, really easy, and computers can do that a lot better now, sort of text recognition, than humans can. And actually, also this sort of I am not a robot bots that has gaps. So that was a response to the task performance on the left-hand side not being adequate anymore, and instead looking at task performance, the system now looks at, it does behavior analysis and looks at IP address, how you move your mouse, how you click, to try to determine whether you're a human or a bot. That might work to some extent, but again, with like very sophisticated machine systems, as were demonstrated by Google DeepMind and AlphaGo, where the top Go player of the world was famously beaten by a machine using reinforcement learning. The same technique can be used successfully against bots. And even if there's a high error rate, say, I run the bot on like 100 sort of, I try 100 times to snap up a ticket, and then say only 1% of cases I'm successful, that only means I need to sort of scale up the sort of attempts that I have to get a ticket to sort of be successful, and that can cause lots of traffic. So these captures are quite come with quite some gaps. Very briefly to sum up, I've got 2 slides left. There's another question around just market and just incentives and markets, you know. Surely it might be bots, but actually concert tickets are usually sold below the market price. And that has various reasons. For example, it's very difficult to sort of, what's the word? Anticipate demand for tickets. So maybe, you know, if you're a concert organizer, you might go for a lower ticket price rather than a higher ticket price to make sure that your venue is full. If you know, because it's very difficult to sort of tell demand ahead of time. And also performers derive other economic benefits from selling tickets that are not the price of the ticket, like selling tickets, motivating future concert attendance, merchandise, and so on and so forth. And that's not just nothing that you and me derive from selling tickets. So it can be very economically sensible for all of us to snap up Taylor Swift tickets, priced below market price, and then to sell them later on. In conclusion, we should probably, you know, if you want to tackle these questions around Ticketmaster crashing, you know, there might be competition concern, but we should also have a think about what are the incentives around reselling, and we probably need a mix of sort of remedies, thinking about financial incentives, which could be the dynamic pricing that was used in the case of Bruce Springsteen and really drove up ticket prices to thousands of dollars, but that could match demand better with supply. Legal remedies like limiting ticket reselling across the EU might be another approach. Also technical means like making it a little bit harder for bots to snap up tickets might be a different approach, because if you use captures on websites, you can actually configure the difficulty for people to fill them out. You know, you might have noticed sometimes clicking certain images is more annoying than sort of on other websites, and that's because you get a sort of probability back. Just anyway, you know, websites have a certain room to maneuver and configure these solutions. Yeah, thanks so much.
Thank you, Konrad. We will quickly move on to the comments, which will be given by Inge Graef, Associate Professor of Competition Law at Tilburg University.
Yeah, thanks a lot. And thank you, Konrad and Caroline as well. I enjoyed reading the paper and listening to the presentation. So what I thought I would do for the okay, now it's working. Thanks. So I thought what I would do for the discussion is to give you some comments that build further on the paper and to share some of the reflections that came to me when I was reading it. So you picked the case, the Live Nation Ticketmaster case, as an example of a vertical merger, where indeed, as you pointed out in the paper, these are usually not the scenarios which are the most problematic from a competition perspective, since there's no direct overlap. Usually the focus is more on horizontal mergers rather than vertical mergers. But still then there can indeed be cases where you deal with a scenario like input foreclosure, where there are competition concerns that deserve more attention. And of course, now the merger has been approved. We can only look at it backwards and see if there's anything we can still do using, for instance, the abuse of dominance framework, or in the US context, the monopolization context. So these issues of vertical integration, I think it's interesting to see that they become of increasing concern. So they indeed deal with companies that have several roles at the same time, and there are scenarios of conflict of interests. So here in this case, we're dealing with a company that does not only promote concerts, but also offers a tickets platform. And one of the concerns that came up after the merger was approved was that Ticketmaster could retaliate against venues or against artists that would not rely on its own ticketing platform. So we have seen something similar in the European context now with the issue of digital platforms, which goes back already to 2019, the point you see here on the slide, with this report that was written by the 3 special advisors to Commissioner Vestager, which pointed out that there are scenarios in this context where platforms act as regulators. So they decide the rules of the game. And this is, I think, also a bit what you see in this Ticketmaster case. So it's a company that is active on several sides of the market, and thereby also decides whether others can still rely on its services, and if they don't, indeed also can retaliate against them. So we've seen in the EU, but also in the US, that these concerns are picked up. In the EU, we now have the Digital Markets Act that goes against these issues of self-preferencing or companies that favor themselves over others that rely on them. In the US, we see something similar. So there is the American Innovation and Choice Online Act, which also has provisions on self-preferencing. And there's even a more far-reaching one, the Ending Platform Monopolies Act, which goes into the direction of requiring divestitures. However, these 2 US acts are not adopted, while the DMA now is being implemented. So there is a distinction when it comes to practical implementation. However, I think the case that you have picked for the paper does not fit within this context. It's not a digital platform targeted by these laws, but that does mean that you can also look at it from the competition perspective. And here I was wondering if the Google Shopping case could become of relevance, because this is a case which is based on a dominant firm. So it's not it's not tied to the gatekeeping nature of Google as such, where you do see the general court acknowledging that self-preferencing can be an independent abuse, and that it's not necessary to rely on the very, very strict conditions of the essential facilities standard. So these are the refusal to deal scenarios that we have seen also in older cases that deal with physical infrastructures. And also the court refers to this obligation of non-discrimination. So it makes an analogy actually with internet access providers to show that when you deal with a big dominant platform like a Google search engine, that there is this idea that these companies have such a responsibility that they should not discriminate versus their clients. So there is, I think, a line of reasoning to be made that a scenario like the one you picked could be a basis of a competition case, even now the merger is approved. So then moving to the consumer protection part of the paper. And here, it's also, I think, an interesting question whether the fact that we are dealing with such a strong firm here, I think it's a firm which has about 70% market share, whether that could also make a difference in applying the consumer law standards. So here, should we argue that greater power comes also with greater responsibility from the perspective of applying the consumer rules? So one of the elements that was picked up in your paper was the Unfair Commercial Practices Directive, where you have the standard of fairness. So one question could be whether you can interpret this open notion of fairness in a way that you indeed expect more when you deal with a very powerful firm, even though, of course, consumer law does not distinguish based on the scale or the power of the company that you're dealing with. And also when it comes to setting priorities for enforcement, you could give attention to these big cases rather than dealing with other smaller firms that might not have as big of an impact or affect as many consumers, even though enforcement of consumer law takes place at the national level. I think we see more and more collaboration among national authorities, where you could also look at the power of a firm as a form of setting priorities. And then I think another point is that it's interesting to see that there's also overlap in the concerns between consumer and competition law. So consumer law deals with consumers having enough information, having the ability to make a proper decision, whereas competition law protects the availability of choice. However, if you deal with a very concentrated market, you might not even have a choice. So it might not matter so much that you still have indeed a lot of information and that there is transparency. So there is here overlap between the concerns of the two regimes as well. And I think this is also an area where we see already stronger collaboration between regulators, but where one can also think of really much more joined up approaches and joined up interpretation of the legal concepts. Then finally, to the role of technology, here switching more towards the perspective of the regulator. I think one interesting element is, or one interesting question is also whether regulators themselves should be using more technological tools to monitor markets. So should regulators, for instance, start using bots to see what is actually happening in that market for tickets? And I know that there has been a discussion in competition law relating to algorithmic collusion, whether regulators should indeed also themselves be applying algorithms to be better aware of what is actually happening. Then, of course, there is also the issue of how can regulators do that. So we see that many regulators are building technology and also data science expertise. The UK is a very good example. The ACM also has data scientists. And this is, of course, also now an issue that the European Commission is dealing with to make the enforcement of the DSA, the DMA effective. How can we hire and bring in these data scientists to also understand the more technical aspects of these cases? And one could think of different models for doing this. So I would hope that your interdisciplinary collaboration between the three of you can also inspire the regulators to also adopt that model for their own enforcement and analysis. So thanks.
Thank you, Inge, for these very valuable comments. Any questions? Yeah.
Thank you very much for a very interesting presentation. I have no question. I just want to share news in Taiwan. We also have a serious scalper problem in Taiwan in the recent years. And you know, many people use robots to collect tickets in the very short time, saying 2 or 3 seconds. Then so many generations cannot buy the tickets, and the scalper correctly buy the tickets and then resell the tickets in the extremely high price. So that young generations complain to our governments. So our governments amend our law just 20 days ago, and saying that if any person who use robot to collect tickets simultaneously and then resell in the much higher price, then that guy can be put into jail up to 3 years. So just sharing information. Yeah, so if we want to do a comparison study, I'm very happy to contribute to in the Taiwanese part. Thank you.
Yeah. Thank you very much for your kind offer, and very interesting to see that this is a global problem. Good. Any other questions? No? Well, that's very good because time is limited. So we will move on to our next presentation. Maria Jose Schmidt-Kessen, assistant professor at the Central European University, will speak about the relevance of human rights and corporate sustainability due diligence for the greening of antitrust law.
Okay, I'll just start a timer to ensure everybody gets to lunch. Right, it's always the same pressure. That's it. No, it doesn't want to. No. Okay. Is it, have you enabled, maybe it's blocked because it's not enabled to. All right, so I'll start with a disclaimer, namely this paper should have never been written in the first place. So around 2019, 2020, I started seeing this literature on sustainability and antitrust mushrooming. And I thought, I cannot possibly add anything to that. And then you learned yesterday that Julian Novak has said it all, right? So I thought, okay, no, I don't really have anything new to say. But then I started teaching business and human rights last year. Thank you. At Central European University. And first of all, it's a very fun course to teach because I have 50% human rights students, 50% business law students. The classroom is a pressure cooker of conflicting worldviews. And I learned a lot myself about human rights due diligence in the process. And while looking at human rights due diligence laws that are increasingly being enacted in various states, I thought there must be a link here. There is some connection between competition law and human rights due diligence. And maybe the human brain is wired to find connections where there are none, but maybe there is a connection. So I'm very curious to hear whether you agree with me here. So let me see how I flick through the slide. Okay. So what I want to do in this presentation is essentially situate my paper within two trends that are ongoing, one in competition law or antitrust and one within business and human rights. I'll then present a hypothesis in my paper, and I will explain in a 3-parameter analysis where I see an overlap between competition law and the sustainability discussions in competition law on the one hand, and human rights due diligence obligations on the other. So what are these two trends? So one trend, I think, is a shift that we can see from the early 2000s mindset in EU competition law that we need a more economic approach, very often associated with Commissioner Mario Monti. Some say it was also Karel van Miert, who was commissioner before, who really launched this push towards having a more economics-based competition law enforcement, to Margrethe Vestager in the context of the Green Deal saying, so the time has come to launch a European debate on how EU competition policy can best support the Green Deal. So to more of a sustainability shift in competition law, and that's what we've been discussing the last day and today. So, and I'm not saying that these two developments one has replaced the other. I think what the European Commission has done in its horizontal guidelines, it's actually merging those two a lot, but there is definitely this trend that is new in EU competition law. I focus in the paper on sustainability as a defense for otherwise anti-competitive conduct. We've heard that there's also the possibility to use sustainability as a sword, as a standard to establish a violation of competition rules. That's not what I'm interested in the paper. So I'm interested in using sustainability as a defense, as we see, for example, in the ACM's guidelines. The other trend is that of human rights due diligence. Can I have a hand? Who knows the UN guiding principles in this room? Okay, then I'll just say 2 words. Okay, then I'll just say 2 words about them. So the UN guiding principles is a framework that came into being under the UN High Commissioner for Human Rights. And it derives from the problem that multinational corporations can rarely be held accountable for human rights violations that occur along their supply chains. And this has been perceived as wrong, but human rights instruments at international level bind states. They do not bind corporations. So Professor John Ruggie from Harvard University helped as a special rapporteur to the High Commissioner of Human Rights of the UN to develop some guiding principles that establish that companies have obligations to comply with human rights, And one of the tools that companies should use to ensure human rights compliance is human rights due diligence. So the idea that companies should carry out human rights risk analyses, they should report on any violations that occur in their operations, they should follow up and monitor any reparation or remedy of those violations, and they should communicate about these to the public. And these were non-binding guidelines, right? But what happened is that various jurisdictions followed up with laws that made those obligations binding on companies. So one example is the vigilance law from France, which obliges companies to carry out human rights due diligence and to follow up on any violations, and opens the possibility for facing civil liability if companies do not take care not to commit human rights violations in their own operations or along their supply chains, or at least with their established business relationships down the supply chains. And in the EU, we're getting now also a binding law, namely the Corporate Sustainability Due Diligence Directive that is in the legislative pipeline, CSDDD in short. And the CSDDD extends due diligence obligations beyond human rights to questions of environmental damage, and even the Paris Climate Agreement target of 1.5 degrees global warming is integrated somehow, that businesses should pay attention in their business plans and should report on how they aim to achieve that goal in their business operations. So very wide reaching law that will trigger a lot of reporting and a lot of jobs for consultants in the future. Now, here we have sustainability as an obligation for companies. This brings me to the hypothesis that I put out in the paper. And that is that, and bear with me, I'll just read it out so everybody can follow. If mandatory human rights due diligence legislation already imposes obligations on companies to implement codes of conduct with their business partners and to monitor their supply chains to ensure they operate in a socially and environmentally sustainable way, okay, that's the if, then any sustainability efforts resulting from these obligations should not be a valid justification for otherwise anti-competitive behavior under antitrust law. So try to catch me already here, okay? Maybe I'm going already astray, but I think this is relatively straightforward. Why should you give a defense to a company for engaging in anti-competitive conduct if they're obliged to do so anyway under the law, right? Okay, now this seems very straightforward, but it's not. I think you need a much more microscopic analysis to make that hypothesis workable in practice. Why is that the case? So again, I try to be a visual person. So maybe this is not the best visualization, but I hope this helps to carry across the point. So companies can engage in a host of sustainability enhancing activities, right? That's the huge circle. Within those sustainability enhancing activities, some of them are mandated by human rights due diligence laws. That's the blue circle. And some of them can constitute a restriction of competition to some extent, but that might have the benefit of a sustainability defense under competition law. So what I try to do with this 3-parameter analysis that I'm going to present is to show how to define this overlap between human rights due diligence obligations and a potential sustainability defense under competition law, which should not be available to companies that are subject to human rights due diligence obligations. So what's the first one? The first one is that we need to look at the company or the companies in question. Why? Because human rights due diligence obligations do not apply to all companies. These laws usually establish thresholds by the number of employees. So, for example, the German supply chain law establishes that since January, companies with more than 3,000 employees are subject to human rights due diligence obligations. And from 2024, it will be companies with 1,000 employees. The CSDDD lowers that standards to companies with 500 employees and in critical sectors to companies with more than 250 employees and a certain turnover threshold. So companies that have less employees than that number should generally be able to benefit from a sustainability defense because they're not covered by the obligation to conduct human rights due diligence. Next, we need to think about the conduct. So human rights due diligence will generally apply to the operations of a company, unilateral behavior, or the company group, which we consider as one economic entity under antitrust law, but also to its vertical agreements along the supply chain. Well, what about horizontal agreements, though? Horizontal agreements are not straightforward covered by human rights due diligence obligations, right? What do we do with those? To be honest, I'm not sure, but I think that also horizontal agreements by companies that are already subject to human rights due diligence obligations should not really have access to sustainability defense if each of these players individually is already obliged to comply with certain human rights and sustainability due diligence activities. Still, maybe engaging in some standardization activity, that can be a way, you know, kind of making it more efficient, exchanging best practices. But then the argument is not that you have a sustainability defense, but the classic argument for a standardization agreement and why adopting same standards is efficient. That is independent in my idea from a sustainability question. And lastly, the objective of the sustainability or the nature of the sustainability objective. So human rights due diligence is very fuzzy. The CSDDD refers to a couple of human rights treaties, to a couple of environmental treaties, and it has that fuzzy provision in Article 15 that you should take into account the Paris climate goals in your business operations. Now, I don't know exactly how this is going to play out, but thinking about the Dutch gardening centers that ban the pesticide, that's probably nothing that can really be found in the kind of due diligence obligations under the CSDDD. So probably there, it would be justified to consider a sustainability defense in this case, or to consider this agreement to fall outside the scope of competition law. But in Germany, for example, we had a case with banana sellers. So it was an agreement between the German, the GIZ, the German International Exchange Organization, and German supermarket chains. And they agreed on selling bananas at a living wage price. So they should make sure that 50% of the bananas sold in the supermarket chains had been sourced from Latin American countries where the workers received a living wage. And the German Competition Authority found that this agreement fell outside. So it was not a violation of Article 101 or paragraph 1 of the cartel law. And here again, I wonder if we now have an obligation under human rights due diligence laws to pay living wage. So workers' rights is one of the main areas covered by human rights due diligence. Would this agreement get away so easily? I don't know. But I think this is a nice headache. And I stop here. And I look forward to the comments. Thank you so much.
Thank you, Marie-José. Comments will be presented by Professor Michael Faure, professor at Maastricht University and at the University of Rotterdam.
Ladies and gentlemen, this is an excellent paper dealing with a fundamental topic in the domain of environmental law and economics, but also in law and economics generally, being how should we trade off various types of market failures. On the one hand, there is a market failure that may result from restrictions on competition. On the other hand, there is a market failure related to negative environmental externalities. Now, the paper deals with the fundamental question of how you should trade off these various externalities and market failures. And Maria-José does this, according to me, in an excellent and balanced manner, as a result of which I largely agree with your analysis. Now, how can we view the problem that she's analyzing from a theoretical perspective? You could say that indeed we have a relationship between sustainability, the dream to move to a green economy and more of those beautiful wishes. You can say from an economic perspective, there is indeed the wish to internalize environmental externalities. And then industry may come in and say, but we can only do that if you are more lenient on the rules of competition law. Now, at first blush, you could say that may make some sense. For example, energy transition may require a knowledge revolution where economies of scale would be of the essence. Then you would say it's important that you have possibility of a collaboration between economic operators that has the advantage that you get new insights at a rapid speed precisely needed to make all of these innovations possible through collaborative efforts. Now, at first blush, that sounds very romantic. At the same time, we have to be very careful in accepting those arguments, as Maria-José, but also Martijn told us this morning. First of all, as a principal matter, it is not at all clear that the innovation necessary for a green transition really rewards the type of collaboration that would go as far as, for example, horizontal agreements. Moreover, you could easily make a reverse argument, especially that horizontal agreements and far-reaching restrictions on competition would stifle innovation and lead to higher prices. In other words, you could say that the competitive process is absolutely needed to stimulate the innovation that we need for the green transition. After all, restrictions on competition usually not only lead to higher prices, but also to laziness and a lack of innovation, as we learned from Michael Porter. And of course, then you get the risk, as Martijn warned us this morning, of greenwashing. There is also, I think, a good reason to be lenient sometimes with the rules of competition in order to stimulate sustainability in exceptional cases, the ones that were advanced this morning by Martijn, for example, in the case of pesticides. But then you always need to be extremely careful, because we know there is always a danger that industry will argue that we need further going restrictions on competition, meaning restrictions that go much further than is necessary to stimulate sustainability. We have seen many examples of that in other sectors where industry was always pleading for group exemptions, and the result was often that there were dramatic restrictions of competition no longer in the public interest. I think, therefore, that when you use this argument that you need restrictions on competition to make a transition to a green economy necessary, that you always have to apply a subsidiarity and proportionality test. Subsidiarity simply asking, can the green innovation not be achieved without restrictions on competition? And proportionality, is it so that these restrictions do not go much further than you would need to justify the innovation towards a green transition? Ladies and gentlemen, I'm basically telling you, in other words, the same what Maria-José was also telling you. So you see that I quite agree with what she was saying. Just 3 minor observations. On page 3, you refer to the guidelines mentioned many times this morning, where you mentioned that they allow for to take broader non-economic considerations into the analysis, including environmental and sustainability considerations. I would in fact phrase that differently, in the sense that I would say these considerations are not non-economic. I rather see it as a trade-off between 2 types of economic market failures. On the one hand, sustainability, but it's also an economic goal. internalizing the negative environmental externality. Second point, you discuss on page 5 these draft guidelines concerning horizontal sustainability agreements, and they introduce a soft safe harbor. I just wondered to what extent these guidelines also allow for the subsidiarity and proportionality weighing that I was referring to. Now, the most important point of your paper is that you discuss, I consider it interesting, interdependencies between competition law and the CSDDD. Of course, I think you can generally ask the question, why compliance with supply chain control obligations should at all be an argument no longer to apply competition law in general. Certainly, as far as horizontal agreements are concerned, and you rightly say so, I don't see the point, because compliance with CSDDD in no way makes horizontal agreements necessary, unless I would be missing the point. Of course, you can say that supply chain control necessitates the imposition of obligations to comply with. In the case of the environment, you mentioned that particular environmental agreements upon the established business relationships within the supply chain. But one has to admit that the way in which the environmental risk is incorporated in the draft directive has been described in a very limited manner, only as the violation of those direct agreements listed in the annex. It only relates to very specific agreements. Again, one has the impression that economic operators falling within the scope of the CSDD could easily, via contracts, as suggested also in the CSDD, impose those obligations upon their contract partners, but again, without necessarily having to take measures that restrict competition in any way. So I guess that here also subsidiarity and proportionality are the key criteria. Summarizing, Maria José, according to me, did an excellent job in warning us that we should be careful with the enthusiasm with which sustainability has been embraced in some antitrust circles as a justification for anti-competitive conduct. I repeat that I could not agree more with that conclusion. From an economic perspective, it makes little sense to cure one market failure of negative environmental externalities by allowing another one of restrictions on competition. And, ladies and gentlemen, we should always keep in mind the wise words of Adam Smith, who warned us already 200 years ago that when the opportunity is provided to businessmen to meet together and to sit together, there is always the danger that they will use that opportunity to conclude agreements that are not in the public interest. That should at all price be avoided and cannot be justified, not even with a call on sustainability.
Thank you, Michael. Very wise words. And I just noticed that you're wearing a tie that is very well in line with the topic of the conference, the Green Deal, Honda tie.
For the many Chinese in the audience, Chair.
Okay, even that. Good. Any questions? Yeah, Julian.
I don't want to like.
I feel like a bit like monopolizing. So I was like looking around whether there are other comments, but thanks a lot. I still have to read the paper. So my comments here are very much based on the presentation, but I'm looking forward to that. Listening to you, I was like partly nodding and partly thinking, no. And I tell you, maybe it's a misunderstanding. And I tell you what the no is. So I'm thinking, so human rights due diligence will be classically, in the case that you described, some kind of vertical agreement, right? So those agreements there, you might think exactly about a competition, reduction in competition, and then you might need to say, well, I need to do that to comply with my obligations that are sustainability obligations. And there, I think could possibly have different options, and you can then think about whether some might be leading to higher sustainability outcomes than others. So there, I think that there might be something there for a defense. I'm just thinking. And the other one is the horizontal one, and there I think we are very, very much aligned. I would have, although, said it slightly differently, and that's maybe we are not aligned. So I was thinking, and we had a quick discussion about it, and haven't looked at it too much, but these kind of agreements that also are referred to in the draft directive are horizontal agreements to ensure compliance, and those you call them standardization agreements. And in that sense, I agree, but then at the same time, I'm not sure, I would not call them sustainability standards. So if they are sustainability standards, then I think the whole debate does become again relevant. And I wouldn't say just because you need to comply with your obligations under the directive and now you're making it more effective to comply with those obligations, that whole debate is outside the scope. I would think, no, it's exactly within the scope. But that's just like, maybe I've misunderstood you and I still have to read it. But those are just like some reflections.
Good. Shall we collect other questions as well? I heard that Oles, who is online, also has a question. Oles?
Yes. Thank you very much, Maria Jose, for fascinating paper. Similar to Julian, I didn't have a chance to read it, so I'm asking for based only on your presentation. And I try to imagine the scenario. I see the rationale that somehow if undertakings are under the obligation to comply with the requirements of sustainability related requirements, this somehow gives you additional, they cannot refer to Article 113 for claiming for exemption. And I think there could be a strong and soft disagreement with this position. And the soft one would be more kind of juristic. The strong one would be more juristic, saying that the obligations of Article 101 are competition focused, and the fact that you have to do something else under something is rather less relevant, I would say. However, if you look at a more kind of policy driven agenda, I would say that these factors could be considered, but not from purely strict juristic standard. It's just an opinion, more than a question. I would be interested in your reflection. Thank you.
Good. Any other questions?
Can I follow up on one? I just like, as Oles was talking, what about state action defense? Because those are like, I think those are the, for those who are not so well versed in that, it's basically a rule where competition law says competition law is not applicable if you're obliged by some kind of rule in a jurisdiction to act in a certain way. But typically it says you shouldn't have any other option of complying with the rule. Just your thoughts.
Okay. Yeah. All right. So thank you so much for the comments. As I said, this is all still very raw. The paper is on SSRN actually, so have a look and see whether in writing it's a bit more clear what I was trying to say. So one of the things that stuck from the comments was that we should stick to the principle of subsidiarity and proportionality, which are main principles in EU law. And so I just thought, okay, this is interesting, but I was just wondering what exactly is meant by that. So I think I might refer a question back. Namely, if we think about subsidiarity in that context, is that because usually we understand that to referring back matters to EU member states that they're better equipped with dealing with, but I think you're saying it should be referred to the area of the law that is better equipped with it. So yeah, I have to think more about it, but that's very interesting. Also to maybe frame that in a more theoretical fashion, how these two legal frameworks should interact. Not there yet, but so thank you for that. About the point that the guidelines are consider non-economic factors, I take the point. That's why while I was presenting, I made that caveat that maybe this is not totally non-economic. It's often framed, especially when we talk about balancing, that this is something else compared to efficiencies. But yeah, I take that point. The fact that environmental concerns that are covered by the CSDDD are very limited, it's true for now. I just wonder, the design is that you include those instruments in an annex, kind of signals to me that that's malleable, so that it might actually increase in the future. So let's see where that's heading. And still we have that requirement to explain to the public how companies comply with the Paris Climate Agreement target, which I think is very wide and broad in that sense. So maybe there's a very broad provision there as well. How hard and how that is going to be enforced in terms of whether companies are complying with that, I don't know. The question about horizontal agreements, and so my point here was that the horizontal guidelines refer to these agreements as standardization agreements that have a sustainability objective. And in the horizontal guideline, it sounds as if we accept the sustainability defense from companies, and even more so if they are jointly trying to find best practice. But let's say, for example, we're thinking about companies building chargers and they agreeing on a common charger. I think not long ago, we would not have thought about that in terms of sustainability in any way, even though we heard that it reduces e-waste. So by now, everything seems to kind of factor into that sustainability. But we would think that that is efficient, that there's an efficiency defense for that standardization. And so in the context of many companies having to comply individually with human rights due diligence and sustainability due diligence, I wonder whether if they get together to find best practices to do that in the most cost-efficient way, it's no longer, to me, that's no longer the sustainability objective that is served, but making things in the most cost-efficient way. So that's why I find that even there, the sustainability goes a little bit analytically out of the window. So just that thought. With all this comment, I have to think more. So why would competition law care about what's going on in other fields of law? I think that policy-wise, yes, of course, we want coherence and so forth, but I really think it helps to identify what's greenwashing and what's not. Because something that is invoked as a defense, that's why I limit the paper very much to the sustainability defense under competition law. It can help, I think, competition enforcers to clean out claims by companies to justify anti-competitive agreements that are not really justified because they already have obligations under the law, which brings me to the state action defense, which I think is very much, it plays out at national law mandating anti-competitive behavior and how that is assessed under EU competition law. But now we would have an EU framework for that. So I just don't know whether we still call that state action. Yeah. So that's why I didn't refer much to that, because for me, that's very much the context of having national laws that oblige companies in some way, and then EU competition law. So yeah, yeah, exactly. And again, that's a argument for immunity, and here I'm arguing for the opposite, that they should not get immunity or a defense, or the companies that engage. Yeah. Thank you so much.
Good. No other questions? Okay, then we can close this session and we can move on to a well-deserved lunch. The afternoon sessions start at 1:45. Okay, and thank you all the speakers, commenters, and everybody who participated from the audience. You know that I think this has a lot of highlights